Good morning and welcome to Perspectives, the program where we delve into today's most pressing societal questions. Today we're tackling a particularly relevant issue in our increasingly digital world. Should employers monitor employees' personal social media accounts? It's a topic that sits at the intersection of business interests, individual privacy, and evolving workplace norms. Joining us to discuss this are two distinguished guests with differing viewpoints. First, we have Mr. David Miller, an experienced HR manager who believes such monitoring can be a necessary tool for companies. And offering a counter-argument is Dr. Emily Carter, a respected employee rights advocate who champions privacy and freedom of expression. Our debate will begin with opening statements from each speaker, followed by rebuttals. We'll then move into a moderated discussion before concluding with closing statements. Welcome, David and Emily.
Thank you, Sarah. Good morning. The question of monitoring employees' personal social media is indeed complex, but I believe it's a necessary consideration for businesses operating in the 21st century. My core argument is that responsible, transparent, and legally compliant monitoring of publicly available information can be crucial to protect legitimate company interests. Let's be clear. This isn't about employers prying into every private message or holiday photo. It's about addressing public conduct that can directly and negatively impact the company. One primary concern is the protection of company reputation. In an age where a single ill-advised post can go viral, businesses are vulnerable. An employee publicly sharing confidential information, engaging in hate speech while identifying themselves with the company, or posting content that severely damages the brand's image can have significant financial and reputational repercussions. Secondly, there's the aspect of workplace safety and preventing harassment. Online threats or bullying originating from an employee, even on a personal account, can spill over into the workplace, creating a hostile environment. Identifying such behavior early can be critical in fulfilling an employer's duty of care to all its staff. Furthermore, while the focus is on personal accounts, the line can blur when employees' public online activities reflect poorly on their professional judgment or associate the company with undesirable behavior. For instance, an employee in a sensitive role publicly glorifying illegal activities could undermine trust not just in that individual, but in the organization they represent. It's also important to consider that employees are often seen as ambassadors for their company, whether they intend to be or not, especially if their social media profiles clearly state their place of employment. Any monitoring program must be developed with utmost transparency. Employees should be made aware of the company's policy, what kind of public information might be reviewed, and for what specific purposes. This should always be conducted within existing legal frameworks, respecting applicable privacy laws. The aim is not to control personal lives, but to mitigate tangible risks to the business, its employees, and its stakeholders. It's a balancing act, but one that modern employers cannot afford to ignore.
Thank you, Sarah, and good morning, David. While I understand the concerns Mr. Miller raises about protecting company interests, I firmly believe that employers monitoring employees' personal social media accounts represents a significant overreach and a fundamental violation of personal privacy. Employees have a right to a private life, distinct from their professional obligations. What they do, in their own time, on their own devices, and on their personal platforms, should generally be outside the purview of their employer. The prospect of employer surveillance of personal social media can create a pervasive chilling effect on freedom of expression. Employees may self-censor their personal opinions, beliefs, or even their harmless personal activities for fear of reprisal or misinterpretation by their employer. This fosters a climate of distrust and anxiety, rather than one of mutual respect and autonomy. It suggests that the employer doesn't trust its employees to manage their personal lives responsibly. Furthermore, the information gleaned from personal social media is ripe for misinterpretation and misuse. A joke taken out of context, a political affiliation, a lifestyle choice. These could all be used, consciously or unconsciously, to make discriminatory judgments regarding an employee's career progression, assignments, or even continued employment. Who decides what constitutes damaging content? The line is incredibly subjective and can vary wildly from one manager to another, leading to inconsistent and unfair application of such policies. Drawing a clear distinction between an employee's personal life and their professional persona online is often difficult, and employers risk overstepping by trying to police this blurry boundary. Are we saying that an employee cannot express a controversial opinion on a political matter on their private Facebook page if they happen to list their employer on their profile? Where does it end? There are existing legal protections and internal company policies regarding confidentiality, harassment, and professional conduct that can address genuinely problematic behavior without resorting to broad surveillance of personal online lives. Focusing on actual misconduct that impacts the workplace, rather than preemptively scrutinizing personal expression, is a more proportionate and rights-respecting approach. Trust, clear guidelines on professional conduct, and robust grievance procedures are more effective tools for fostering a positive and productive work environment than surveillance.
Dr. Carter, you've raised important points about privacy, and I want to reiterate that the kind of monitoring I advocate for is not about indiscriminate snooping into every corner of an employee's private life. We are specifically discussing publicly accessible information that an employee chooses to share, which could reasonably be seen to impact the company directly. If an employee publicly posts threats against colleagues or discloses sensitive company trade secrets, this isn't a purely private matter. It has direct and serious consequences for the business and its people. You mentioned a climate of distrust. I would argue that a transparent policy clearly outlining what is considered problematic public conduct and why can actually build understanding. It educates employees on the potential impact of their public digital footprint, rather than leaving them to guess what might be crossing a line. This isn't about controlling thoughts, but about managing actions that have tangible repercussions. When an employee publicly disparages the company's clients or creates a hostile environment through their online actions that then bleeds into the workplace, the employer has a responsibility to act. This isn't about lifestyle choices or private political views, unless those views are expressed in a way that incites violence or discrimination directly linked to their professional role or the company. The focus remains on mitigating clear and present risks to the company's reputation, its operational security, and the safety and well-being of its entire workforce. It's a protective measure, not a punitive one. By default.
Mr. Miller, while I appreciate your emphasis on publicly accessible information and toward impact, the reality of implementing such monitoring is far more problematic than this idealized vision suggests. You state it's not about lifestyle choices, but who makes that determination? An HR department or a manager might view participation in a legal protest shared publicly as, quote, damaging to the company's image, especially if the company has clients with opposing views. This is where the subjectivity becomes dangerous. The argument that existing laws and internal policies regarding conduct and confidentiality should be sufficient still stands. If an employee harasses a colleague, whether online or offline, there are disciplinary procedures. If they leak confidential data, that's a breach of contract and potentially illegal. We don't need to add a layer of continuous, preemptive surveillance of personal accounts to address these issues. Furthermore, the quote, chilling effect is very real, even with transparent policies. Knowing that your employer could be looking at your personal social media, even if it's just the public parts, makes people inherently more cautious, less authentic, and potentially less engaged in their own private lives and civic discourse. This isn't conducive to a healthy work-life balance or a workforce that feels trusted. It can lead to employees feeling like they are under a microscope 24/7, which is a significant psychological burden. The potential for bias in interpreting online content is immense, and the resources required to monitor fairly and ethically across a large workforce would be substantial and likely ineffective in truly preventing harm without overstepping.
Thank you both for those robust rebuttals. This brings us to our discussion segment. Mr. Miller, Dr. Carter raises significant concerns about the potential for misinterpretation or discriminatory use of information, even if it's publicly available. How can companies genuinely ensure that monitoring, if implemented, is conducted ethically and without bias, especially given the subjective nature of what might be deemed quote, damaging?
That's a critical question, Sarah. Firstly, any such policy must be developed with clear, objective criteria for what constitutes a reviewable concern. These criteria should be narrowly defined, focusing on specific harms like threats, harassment, disclosure of confidential data, or hate speech directly linked to the company or its employees. Secondly, the review process itself should not be arbitrary or left to a single individual's discretion. A multi-person panel, perhaps including HR, legal, and even an employee representative where appropriate, could review potential issues to ensure diverse perspectives and reduce bias. Training for those involved in reviewing such information is paramount, focusing on cultural sensitivity, unconscious bias, and the importance of context. Such documentation of all reviews and decisions would also be essential for accountability and transparency. Ultimately, the system should be designed to flag only the most serious, unambiguous breaches that pose a direct threat, not to scrutinize general opinions or personal activities.
Dr. Carter, Mr. Miller argues that some level of monitoring of publicly available information is a necessary evil to protect company reputation and safety, particularly against clear threats or damaging disclosures. Where, if anywhere, would you concede that an employer might have a legitimate, albeit very narrow, interest in an employee's public social media activity?
My fundamental position is that proactive, continuous monitoring is an overreach. However, I would concede that if an employer becomes aware, through other means, say, a direct report from another employee or a client, of a specific public post that contains, for example, a credible threat of violence against a colleague or explicitly leaks sensitive company documents, they have a duty to investigate that specific instance. This is reactive, not proactive. It's about addressing a clear and present danger or a definitive breach that has been brought to their attention, not about trawling through employees' personal lives hoping to find something. The line for me is crossed when employers actively seek out this information or implement systems for ongoing surveillance of personal accounts. The focus should be on the impact and nature of the behavior itself, not on the platform it occurs on. And action should be based on tangible harm or direct breach of existing, well-understood policies.
A follow-up for both of you then. Mr. Miller, how do you respond to Dr. Carter's distinction between reactive investigation of a specific, reported incident versus proactive monitoring?
While reactive investigation is certainly part of the toolkit, relying solely on it can mean acting only after significant damage has already occurred. Proactive monitoring, when narrowly focused on public posts that might indicate imminent threats or serious breaches of conduct that could escalate, aims to be preventative. For example, if an employee is publicly making escalating threats online towards the workplace, waiting for it to be quote, reported might be too late. The key is that proactive doesn't mean all-encompassing. It means having systems to identify high-risk public expressions that directly pertain to company safety or integrity within strict ethical guidelines.
And that quote, high-risk public expression is precisely where the subjectivity and potential for abuse lie, Mr. Miller. What one system or HR manager deems high risk could be another's legitimate, if perhaps strongly worded, personal opinion. The potential for overreach in a proactive system is inherently greater. Relying on clear reporting mechanisms for actual misconduct or policy breaches, coupled with robust investigation of those specific incidents, remains a more rights-protective approach. It places the burden of proof on a tangible event or action, not on a preemptive scan of personal lives.
In closing, I want to emphasize that advocating for the ability to review certain public employee social media content is not born from a desire to control or intrude. It stems from a genuine need to protect the company's legitimate interests, its reputation, the security of its information, and crucially, the safety and well-being of all its employees. We live in an era where the lines between public and private are often blurred by technology, and the impact of online actions can be swift and severe. To ignore this reality would be irresponsible. The approach I've outlined is one of responsible oversight, governed by principles of transparency, legality, and narrow focus. It's about identifying and mitigating clear, tangible risks that publicly manifest, not about scrutinizing private lives or personal beliefs. We must find a balanced approach, one that respects employee privacy, but also empowers employers to act when necessary to prevent significant harm. This isn't about choosing one over the other, but about finding a workable, ethical framework for navigating these challenges in the modern workplace. It's about safeguarding the collective, while still respecting the individual.
Today's discussion highlights a critical tension between employer concerns and fundamental employee rights. My position remains firm. The routine monitoring of employees' personal social media accounts is an unacceptable infringement on privacy and freedom of expression, regardless of how transparently it's framed. The potential for misuse, misinterpretation, and discriminatory application of such surveillance is simply too high. It fosters an environment of suspicion and self-censorship, undermining the trust that is essential for a healthy and productive workplace. Effective management relies on clear policies regarding conduct, confidentiality, and harassment, policies that apply regardless of where misconduct occurs. Addressing specific, reported incidents of harmful behavior is far preferable to preemptive, broad-ranging surveillance. We must prioritize the creation of work environments built on mutual respect, trust, and the understanding that employees are entitled to their private lives outside of work. Upholding these principles is not just an ethical imperative. It is also key to fostering genuine employee engagement and loyalty, which are far more valuable assets than any information gleaned from monitoring personal social media.
And with that, we must conclude our debate. My sincere thanks to both Mr. David Miller and Dr. Emily Carter for their articulate and passionate arguments on this complex topic. We've heard compelling points from both sides. Mr. Miller emphasizing the need for employers to protect company assets and ensure safety through responsible monitoring of public information. And Dr. Carter championing employee privacy, freedom of speech, and warning against the potential for overreach and distrust. It's clear that there are no easy answers, and the balance between an employer's interests and an employee's rights in the digital age is a delicate one. We hope this discussion has provided our audience with valuable insights and encouraged further reflection on where these lines should be drawn. Thank you for joining us on Perspectives. Good morning.